Rajiv Gandhi assassination, president and not governor, the competent authority to pardon Perari villains entered Del Supreme Court. In the matter of release of AG Perari villain, the convict in the Rajiv Gandhi assassination case, the center on Wednesday submitted that it is the president under Article 72 and not the governor under Article 161 who is competent to grant pardon or remission. If the entire representation was given to an authority which lacks the jurisdiction to consider the representation, then the right which is being urged on account of the inaction of the governor, which he says infringed his Article 21, cannot be recognized at all. Advanced Additional Solicitor General K.M. Natras. Now, the state government had recommended the release. There were no orders passed by the governor for over 2 years. The governor is acting for the executive now. He can't say if you are aggrieved by the decision of the government, challenge it. This is an extraordinary situation where the recommendation was made by the government and the orders were not passed, indicating Article 72, as per which the power of the president to grant pardon and remissions extend to the executive power of the Union. The Additional Solicitor General took the bench through Article 73, which explains that the executive power of the Union extends to all the matters on which the Parliament has the power to make laws. Next, as regards Article 161, he advanced that the power of the governor is restricted to the extent of the executive power of the state or the power of the state government to make laws. Senior advocate Gopal Shankar Narayanan, appearing for the petitioner, pointed the bench to the proviso to Article 73, which states that the executive power referred to in the article shall not extend in any state to matter with respect in which the legislature of the state has also power to make laws unless expressly provided in the constitution or in any law made by parliament. To buttress his argument, the additional solicitor general relied on the majority judgment in the 2014 Shri Haran's case decided by a constitution bench, where the Union of India had challenged the letter dated 19 February 2014 issued by the Chief Secretary, Government of Tamil Nadu, to the Secretary, Government of India, wherein the state of Tamil Nadu proposed to remit the sentence of life imprisonment and to release the seven respondents who were convicted in the Rajiv Gandhi assassination case. Now, the status of appropriate government, whether union government or the state government, will depend upon the order of sentence passed by the criminal court has been stipulated in section 432 clause 6, and in the event of a specific executive power conferred on the center under a law made by the parliament or under the constitution itself, then in the event of the conviction and sentence covered by the said law of the parliament or the provisions of the constitution, even if the legislature of the state is also empowered to make a law on the same subject and coextensive, the appropriate government will be the union government, having regard to the prescription contained in the provision to Article 73, subclause 1, clause A of the Constitution. Now, the principle stated in the decision in G.V. Ramnaiah should be applied. In other words, cases which fall within the four corners of Section 432, subclause 7, clause A, by virtue of a specific executive order conferred on the center, the same will clothe the union government, the primacy with the status of appropriate government, barring cases falling under Section 432, subclause 7, clause A, in all other cases where the offender is sentenced or the sentence order is passed within territorial jurisdiction of the concerned state. The state government would be the appropriate government, the bench had ruled in Sri Haran case. Not once has his objection been raised by the Union of India before your lordship all these years in your September 6, 2018 order. Your Lordship said that an application under Article 161 to the Governor has been made and that the Governor will decide the same as deemed fit. There was no objection to it by the Union of India then. They pop up every 5 years whenever liberty arises and raise objections. From Nanavati till today, for 70 years, all such questions have been uh, within the executive domain of the governor and have been dealt with by him. Today, the Union of India is saying that what we have been doing for 70 years is wrong. For all the 90 lakh convicts across all jails in the country, the mercy petitions can lie only to the President of India. They are saying that since the IPC is a central act, every exercise of every governor for the last 70 years is wrong. It is obnoxious on the part of the center. The Union of India can take up this question. Your lordships can leave this question open, but this is not a fit case for this. A man who has been languishing in jail long enough cannot be asked to wait for an answer to this question of law raised orally at the last minute on behalf of the Union of India, he pressed. So now government of India has stopped from questioning the governor's competence. The Shankar Narayanan proceeded to give the bench a background of how long the petitioner has waited for liberty. This was an extraordinary case where a teenager was taken for questioning in 1991 following the assassination of a former prime minister. Subsequently, it was found out that he had been held in custody for 18 to 19 years. He was held in solitary confinement. He was on death row. The Tada Act convicts him and he was awarded the death sentence. The Supreme Court said that the Tada conviction was wrong and set it aside but retained the conviction under Sections 120 Clause B and 302 of the IPC and the Arms Act. This sentence has been served out, narrated this senior counsel. He continued to elaborate that the Tada confession was used for the Section 302 conviction, that a mercy petition was filed in 1999, and which was rejected 12 years later in 2011. Then there was the proposal for remission under sections 432 to 435 of the CRPC. The state government considered the remission and the central government in 2014 filed its challenge to the possibility of remission. The matter went to the Constitution Bench in Sri Haran case. On 18 April 2018, the central government rejected our application for release under the CRPC on the state government proposal. Because of the delay, the principles of Shatrughan Chauhan case, where the Supreme Court said that the mercy petitions have to be decided in a time-bound manner, kicked in, and the sentence was commuted from the death penalty to life imprisonment. He continued. Then another mercy petition was filed on December 30, 2015, which has not been acted upon till date. On December 12, 2017, the petitioner brought to the notice of the top court that the former DGP of the state of Tamil Nadu, who was the investigating officer of the case and had taken the Tada confession, has stated that he has committed a mistake, that he had excluded the exculpatory part of the statement, and that the petitioner had no idea why he was buying the two batteries that went into making the bomb. From the document filed on 1 September 2018 by the Learned Council, it appears that an application under Article 161 of the Constitution has been filed before the Governor of Tamil Nadu by the respondent AG Perarivalan Arivu. Naturally, the authority concerned will be at liberty to decide the said application as deemed fit. It had directed there was an entire cricket team worth of counsels representing the centre then. Nobody took the objection that please record that 161 is not available. The order was also not challenged. this is the first estoppel to the government of India, pressed the senior advocate of India has in February 2020. Sorry, the Union of India has in February 2020 said that the Ministry of Home Affairs has rejected the proposal of the Tamil Nadu government under Section 435 of the CRPC that it is pending before the Governor of Tamil Nadu. This is the second estoppel to the government of India, argued Mr. Shankara Narayan. He indicated that in a September 26, 2018 news report, the governor is quoted as saying that the petitioner cannot be released till the plea of the collateral victims of the bomb blast, which was then pending before the Supreme Court, is decided. The same petition came to be dismissed on May 5, 2019, so the first hurdle went away, commented the senior counsel. Secondly, on September 24, 2020, during the course of parole proceedings, the Madras High Court observed that the governor is waiting for the final report of the multidisciplinary monitoring agency, which is looking into the angle of larger conspiracy behind the case. The CBI came to file its affidavit on November 20, 2020, saying that it has not received any request from the governor to divulge details of the investigation. It further said that the present petitioner is not the subject matter of further investigation by the MDMA. So now the second hurdle is also not there, commented Mr. Shankara Narayan. Shankara Narayan referred to the Nilofer Nisha judgment of the Supreme Court, where he said the court exercised power under Article 142 to order the release of prisoners in Tamil Nadu who were covered under the same remission notification which dealt with Perari Velen as well. The state of Tamil Nadu had under Article 161 framed guidelines for release of convicts who have been in jail for more than 10 years. Habeas corpus petitions were filed by prisoners who don't have the benefit of these guidelines. Your Lordship said that since they are not in illegal custody, no habeas corpus can lie. Your Lordship asked them to make a representation to the government to be decided in 3 months, explained the senior advocate. Your Lordship had even take up the cause of the respondent before the Supreme Court. All of them were 302 cases, as am I. They had been in jail for 10 to 16 years. I have been in jail for 30 years. Your Lordship had looked at their conduct qualification and you released a total of 4 convicts under Article 142, he narrated. He urged that Nilofer Nisha should apply to Perari Valan also. Here the government took a decision of release. The cabinet even recommended it. The gap is only of the signing of this recommendation by a governor who he argued is bound by the recommendation. I have attached photos and certificate in support of my resplendent record of conduct. I was let out on parole on 4 or 5 occasions, and there was no risk. I went quietly, undertook the medical test, and came back. I also I also have old parents who are on their last limb. Please look at the certification obtained by me during the period of incarceration. I undertook the highest senior secondary exam and scored 91.3%. I have also acquired a diploma in desktop publishing. Even if my guilt is complete, it is clear that I have been trying to make myself better and assimilate myself in the society, submitted Mr. Shankara Narayan. So, are you covered under the government order dealt with in the Nilofer Nisha case? Asked the bench. No, because we are covered under Section 435 CRPC. After consultation with central government in certain cases of commutation remission, replied the senior advocate. That's all for now. Thank you.